Absolutely. The biggest hurdle that we have in negotiating these cases and in getting the best result is when people have prior DUIs. Prior criminal records, not as big of a deal as prior DUIs specifically. The penalties are so much greater for second, third, fourth, or more DUIs within the last 10 years. Even when a prior DUI is stale, meaning the arrest is more than 10 years before the arrest for this new case that we're in court in, they will still take that into consideration. And the DA's offer is usually not as good as if you had a clean record or a record with no DUIs on it. So prior DUIs are a much bigger hurdle. Prior DUIs from the beginning in a case will make it tougher in dealing with the case and dealing with the court, and tougher consequences often on the client from the beginning, because the judge may be more likely, and usually Marin County is more likely to order you to have an alcohol monitor on if you have a prior or two prior DUIs within the last 10 years, especially if they're more recent or you're still on probation. And having to wear that monitor for a certain amount of time or months to show that you're not drinking, so that can have a big effect. But the penalties are greater when you have prior DUIs that within the last 10 years. The maximum penalty doubles on a DUI if you have a prior within 10 years. Fines are greater, minimum, penalties, whether it's jail or alternative services, is much greater. DUI school is a lot longer. We're talking about an 18-month DUI school versus what's typically a 3-month DUI school. So there's a lot more to deal with when you do have the prior record, especially when the prior record involves prior drunk driving, DUI conviction or convictions.